Welcome, friends. Are you really scared of giving your property on rent? Are you really scared of giving your office, which is lying vacant, or which you may have a spare one, on giving it to somebody on rent or on lease basis? Perhaps you may not like to give it to somebody on rent simply because you think that after taking it on rent or on lease, that person might not vacate the property whenever you want it back. These are some of the questions, and I'm also going to talk about some remedies or some ways, some legal arrangements that can be done or that can be executed while giving your property on rent, or the terminologies that can be used for executing an agreement between you and your licensee. Thank you, my dear friends, for once again coming back to my channel. And this is Shah Mishra, and you are watching Knowledge Graph. Let me just tell you very quickly what are the three sort of arrangements or agreements which can be executed in a rent agreement. The first one is called a rent agreement, as you all know. The second one is called a lease agreement, and the third one is called a leave and license agreement. Basically, the first two, the rent agreement and the lease agreement, are similar, and the third one, the leave and license agreement, is basically governed through a different section. The first two, that is the rent agreement and the lease agreement, are governed through the Transfer of Property Act, and leave and license agreement is basically governed and executed through the Indian Easement Act. There is section 52 of the Indian Easement Act. Basically, I would suggest that whenever you are giving any property on rent and you are a landlord or a owner, you should try to give your flat or your premises on leave and license basis only. There are 2, 3, 4 reasons to sum it up very quickly. There are 2, 3, 4 reasons why you should try to give your property on leave and license basis and not on rent basis or on lease basis. The first and the foremost thing is that on a rental, whenever you execute any rental agreement or any lease agreement, the interest in your property get transferred to your tenant or to your lessee. So perhaps you may not be aware that as per Transfer of Property Act, an interest is created whenever there is a deal between the landlord and the tenant. An interest is created in favor of the tenant, and to avoid that interest, what you should do is you should try to execute a leave and license agreement wherein no such interest is created in favor of the tenant or the licensee. The second thing is that this leave and license agreement is not transferable. That your tenant cannot really further sublet or further lease out your property in case your agreement is based on or executed on the basis of leave and license. Whereas if you do an agreement, if you do a lease agreement or you do a rent agreement, your tenant can further sublet that property, or he can become a landlord and further create a subtenancy in that. So basically, to avoid this situation, I think one should go for a leave and license agreement. The third one is that it is non-heritable. That is, leave and license agreement, it cannot be transferred to your heirs. Whereas in a rental agreement or in a lease agreement, the interest of your agreement or the tenancy gets transferred to your legal heirs. That is, in the case of mishappening, if the tenant dies, this agreement, the benefits or the interest, whatever the clause the agreement has been, whatever the clause that has been used in the agreement, gets transferred to their legal heirs. And sometimes it really creates a problem later on. The fourth thing that I would like to tell you as far as the difference is concerned, in a lease agreement, the lessee, or in an agreement or a rent agreement, the tenant can really take the basic amenities, the water and the electricity, etc., in their own name, which they normally use later on to claim occupancy over that property. Whereas in a leave and license agreement, no such thing can be done. The other point, or maybe the last point, is that the legal occupation, the legal occupancy of that property in a leave and license agreement always remains with the licensor. Whereas in a lease agreement, the occupation and sometimes the legal occupation also, the legal possession also, gets transferred to the lessee or to the tenant. because this possession is a very critical word as far as these agreements are concerned, or in any transfer of property act. This occupation or a possession of a property really creates a major ingredient in deciding as to whether any interest in the property has been generated through the agreement that has been executed by the parties. So, not to sum up, not to go any further, I would just request you to just execute a leave license only if you are a owner, and if even if you execute a lease agreement, then also you should try to inculcate, or you should try to include some points wherein you should clearly mention that the legal ownership of the property shall always remain with the licensor, or if you are using the word lesser, shall always remain with the lesser. These are some of the lines that you can use. You can also have to include the basic terms in agreement, like what is the notice period. You should also try to very clearly mention that no interest in that property shall get transferred from the lessor to the lessee. Though I have told you already that you should always go for a leave license, but still, in case you have executed a lease agreement, then also you should try to include this clause, because when you include this clause, the tenant or the lessee does not get any tenancy rights, because as and when he gets the tenancy rights, lot of this Model Rent Control Act gets transferred in his favor when the case really goes in to any court. So these are 4 to 5 points that I was trying to tell you. Apart from this, there is another term which is normally used. There are two things rather I would say. One is the enjoyment of property, and one is the occupying that property. You should write a clear line or a clear clause in the agreement that the lessee or the licensee cannot enjoy that property. He can only occupy that property, because if you give the right of enjoyment to your tenant or to your lessee, then a further interest is created in their favor, which can really act as an impedient or as a bottleneck whenever you are fighting a case with your tenant or with your lessee. So thank you very much. I wanted to keep it short. In the next video, I would like to explain you more about the legal points that can really be inculcated or that can really be included in your agreement, because otherwise the video will become very long. I just wanted to make a very short video, and then further videos will come. This was basically a video for people who cannot understand Hindi. I have also made a video where I have that's a long video basically in a Hindi format. This one I have tried to make this video for people who are not that well conversant with Hindi, or may not understand, may not belong to the northern part of India. Thank you for watching this channel. If you like my video, please subscribe my video, and also share my video, and please subscribe my channel and hit the bell icon if you like my video. Thank you. See you again in our next video. Thank you for watching me.